Good afternoon, everyone. My name is Vijay Bhandari, and I welcome you all in the Masterclass of Franchise Selection and Contract Negotiation. Today, I have a very dear friend, Ashish Pyasi, a very eminent lawyer, currently designated as an associate partner with Dhir and Dhir Company, which is one of the India top five leading law firm. Today, topic for Masterclass is franchise selection and contract negotiation. So we will take you through a complete journey of franchise selection till the contract negotiation through this presentation. When hotel owner is looking for a option to tie up with the brand, so there are two options available. One is a management contract, and second is a franchise contract. And most of time we find owner they have an ambiguity between the management contract and a franchise contract. So what we did, like we have identified 27 points where we can differentiate between a management contract and a franchise contract. So what are those points? What are those parameters? So to quickly run you through, we have around 27 parameters. The first parameter is a hotel branding and marketing. So if you are going for a management contract, you get a hotel branding and marketing rights, as well as the same time in franchise also you get hotel branding and marketing support. Routine hotel operation management. In a management contract, routine management is remain with the owner. In franchise contract, owner has to look after for day-to-day operations. Annual financial budgeting. In a management contract, annual financial budgeting is done by the brand, and in franchise contract, the annual financial budgeting is done by the owner. They just get a advisory and support role from the brand. Where the property will be part of the complete distribution website brand.com. Yes, in a management contract as well as in a franchise contract, the property will be listed on a brand website. OTA special rate benefit. Yes, in a management contract as well as in a franchise contract, brand will extend you the support of OTA tie-up as well as the special rates. Revenue management. In a management contract, the revenue management is done by the brand, but in a franchise contract, revenue management is done by the owner, but they get a support from a brand. Human resource management. In a franchise contract, human resource management is done by the brand. In franchise contract, human resource will be managed by the brand only, from the owner only. Training and development. Management contract, brand take care of the training and development. In a franchise contract, the owner has to look into the training and development of the staff. The 9 pointer is a business from regional sales offices. Yes, in a franchise as well as in a management contract, you get a support from the regional sales offices. Pre-negotiated rate from vendors. In a franchise as well as in a management contract, brand they offer you a pre-negotiated rates from the vendors, so you have a better saving on the supply side. Control on the hotel and decision making. This is one of the critical and important point why most of the owner choose franchise over a management contract. That complete control of the hotel and decision making is with the owner, not with the brand. Bank account revenues and expenses. Bank account in a management contract is jointly managed between the brand and the owner, but in a franchise contract, bank account revenue and expenses all managed by the owner. Service standard and guidelines. Both the in both the cases, SOP will be set up in a franchise as well as a management contract. Property upgradation and the product development. In a management contract, all the property upgradation, repair, maintenance, everything call will be taken by the brand. In a franchise contract, there is a minimal involvement of a brand, but all the property upgradation call will be taken by the owner. Operating liabilities. The day-to-day operations in a management contract is with the brand, so the operating liability belong to the brand. But in a franchise contract, all the day-to-day operating liabilities is with the owner. Operating license renewable. If you have a management contract with the brand, the first year of operation you have as an owner, you have to bring the licenses, but once going forward, brand will renew it. But in a franchise contract, the responsibility of operating license renewal is remain with the owner. Decision on room rates and F&B pricing. In a management contract, decision of room rates and the F&B pricing is done by the brand. But in a management contract, owner is free to take his call on a room rates and the F&B pricing. Global distribution support. In both management as well as franchise contract, you get a support from the brand for a GDS. Assistance in upgradation. Yes, in both the cases, brand will provide you assistance in the upgradation. Local sales team. Local sales team in a management contract will be hired by the brand, but in a franchise contract, it will be with the owner. Responsibility of enhancing the revenue in a management contract is remain with the brand. In a franchise contract is remain with the owner. Responsibility of operating expenses in a management contract it is with the brand. In a franchise contract is remain with the owner. Management of books of account in a management contract is done by the brand, but in a franchise contract is done by the owner. Collection of account receivables in a management contract is done by the brand, but in a franchise contract is remain with the owner. Maintenance of hotel property in a management contract, day-to-day repair maintenance as per the F&E reserve is done by the brand, but in a franchise contract it is done by the owner. So now we have also giving you a parameter like what fees is charged on a total revenue. So generally in a franchise contract, the fee is charged on a room sales, but how those fees impact on the total revenue. So in a management contract, we have divided into two parts, domestic brand as well as international brand. So if you are doing a management contract with a domestic brand, the overall fee will be somewhere around 6% average. And if you are going ahead with the international brand, it's somewhere fall into 8.5% of total revenue. If you look into a franchise contract, the total fee on a total revenue is around 3.5. If you're going ahead with the international brand, it's somewhere around 4.5 on a total revenue. Terms of contract in a management contract are generally long-term contracts ranging from 15 to 30 years, and franchise contracts are generally ranging from 10 to 15 years. For hotel owner, why branding is required? First and the foremost is to get a first and foremost important is to get the advantage of established brand, because currently the market is highly competitive and there are several similar products. So how do you differentiate your product from other? For that, the branding is required. Second is to increase the rates and occupancy. Third is to have a better reservation system and distribution. Fourth, to have a sales and marketing support. Most of the brand, they have their offices, regional offices across India. They have a corporate, they support you in the corporate booking, RFP booking. They help you with the MICE business as well as the group bookings. Fifth, the more important point is the loyalty program. Most of the brand, they have loyalty members who like to redeem their loyalty points in the properties. And so one property or a second property, whatever the loyalty points have been generated by the guest can be consumed or utilized in the other properties. So one of the biggest advantage of branding is to get a support of loyalty program of the brand. Six is a better guest profile and a trust. Generally, like if a hotel is a branded hotel, the guest profile comparatively from a non-branded hotel is better, and the trust of the guest is higher on a branded hotel compared to a non-branded hotel. Brand provide you a standard operating procedure. You have to follow that standard operating process, and you can attract a better staff and talent through a branding. And the last point is a better asset management, because brand do a regular audit of the assets and they will help you with the asset maintenance as well as the management. And end of the day, like the valuation of your hotel is higher in a branded if it is a branded property. Now, how do we select the right franchise brand? So that's the more important part. How do we select the right franchise brand? So first and the foremost thing, if any hotel owner is looking for a conversion or either building a new hotel and looking for a brand tie, for him, the first and foremost thing is to get the feasibility or a property assessment done from a professional consultant. See what happened in a feasibility study. Sometimes we find that hotel owner underestimate the importance of a feasibility. So before going for a tie-up, you have to understand the complete property, the catchment area, the market where the business is coming from, and with the help of feasibility, you will understand which are the competition currently are, what are the future supply coming up, and where there is a oversupply or undersupply. So to bridge that gap, a feasibility study is very important while selecting a franchise brand to know where the property stand and which kind of brand should go to have a proper impact of a branding. Second, when you done a feasibility study, you can send the copy of feasibility study along with your property fact sheet and get a franchise proposal from the brands. Then you can do a comparison of all the commercial and non-commercial terms of a franchisee brands. And then you identify a total cost of franchising versus value. What are the upfront fee? What kind of PIP is required? If it's a conversion, what kind of a property improvement plan and investment is required? When you do that, also do a NPV analysis, which is the net present value of a fee of a brand on a 10-year projections. And in how much time you can get a payback of whatever the investment is going in a brand upgradation, as well as the upfront payment you are making to the brand, and see how a brand can increase the valuation of your property and how the performance of your hotel can be improved. In the last, when you do all this comparison, a brand which is offering you higher value with a competitive fee, and owner is happy with overall number crunching, then owner can select that brand. And once you select that brand, also make a also go and meet the existing franchise owner, what kind of support they are getting from the brand. These are the points which a hotel owner can consider while selecting a good franchise brand. So now we come to the contract negotiation. What are the major terms are involved in the in negotiating a franchise contract? First and the foremost condition which is an important clause in a franchise contract is the brand name and suffix. So generally, like in a franchise contract, you can negotiate the brand name along with the suffix. So suppose like if you are a hotel in Bombay which is running from last 10-15 years, you already have a brand equity of that property. So a lot of international and Indian brands, they allow you to merge a brand name with a suffix. So today, if you're deciding a ABC brand, you can also use ABC along with the suffix of your choice. So this is an important point that you can negotiate with the brand. Ashish, you like to contribute something on that?
Yes, suffix plays a very important role
Yeah,
because later, once you part ways, it becomes very important whether you can use it for your own purpose or not. Because maybe one of the condition of the agreement may provide, because when a brand is coming, they would also suggest that you can't use the same name. So the brand name, say ABC, and the suffix which is used,
yeah,
which is suggested by you may not be available to you after the end of the agreement or the termination, whenever whatever happens. So it becomes
sure.
really important that when you're using a suffix, when you are trying to capitalize your brand value, because you have over the period of years, you have also developed some brand value. So when you are adding that suffix, you need to be a bit careful, and when you are negotiating the agreement, you should negotiate on this also whether you can use this suffix later on or not. So this is
Okay,
something which plays very important role because this is the brand which you have developed over years.
sure.
So it's a very important point in that sense. So
Okay.
moving on to the next one, I would say
The next clause in the agreement which you need to look into is the tenure of the agreement. So generally, the franchise agreement is between 10 to 20 years. You can negotiate. Uh, Ashish, would like to highlight what should be an ideal tenure for an agreement?
so. Earlier, what used to happen, the tenure used to be say 20 to 30 years, but of late we have seen that the tenure has been reduced because of the changing dynamics. We have seen people opting for 10 to 15 years of tenure of the agreement, and people also offer a lock-in period. Now, lock-in period is very important from the bank perspective as well as from the property owner perspective, because it should not happen, because it is heavily capital intensive also when you're trying to upgrade the property so that it matches the brand standards. You are incurring lots of expenses also. So when you are incurring these capital expenditure, it is very important that there should be a lock-in period also, so that there is no withdrawal from the agreement all of a sudden, and your investment are protected to that extent. So the tenure, ideally, I would suggest, considering the current scenario also because of the COVID and other recent economic slowdown also,
Yeah.
10 to 15 years is the ideal time which a brand owner as well as property owner should look at.
Okay.
So yeah. So moving
So
on to the
moving,
next one, Vijay. Yeah.
yeah. So moving on the next one, opening date, which is one of the very critical and important factor to negotiate in a franchise agreement, because most of your termination clause or a penalty is linked with the opening date. Ashish, you'd like to highlight on this?
Yes. Yes. So opening date is very important because there are certain projections, there are certain plans which are already there in the standard procedure and the manual which has been circulated.
Yeah.
And if there is a delay, now in the recent you know uh, situation, we have seen that because of the COVID situation, the
Yeah.
opening date has to be delayed. So that is something which is very important. That how you assess this situation. Also, if there is a protection in the agreement and parties are negotiating, so we should also try to capture these kind of circumstances where the circumstances are beyond the control of the parties which are involved. Also, if there is any delay in the opening date, it also results into certain penalties, as you have also mentioned. What generally
Yeah.
happens is there is already a liquidated penalty which is already provided in the agreement, because the brand owner, the brand will also insist for a penalty, because if there is a delay, their business is also getting affected. So they insist for a penalty. Whereas owners have to be a bit careful, because if there is a delay, obviously their revenues are also going to hit. So, but the penalty comes into the picture, and also if this defect is not cured for a very long time, the agreements also provides at times, because it can't be for indefinite period also. So it may lead to termination also, which will have a severe repercussion on the arrangement between the parties.
Sure. So moving to the next clause, a property improvement plan. Whenever you are tying up with a franchise brand, if it is a new property, then they will just do a complete brand property audit and suggest you what are the changes is required. And generally, a new property changes are related with the software and minor changes related with the FLS norms. But if it is a conversion, if your property is already operating from last 5 or 10 years, when a brand come, they do a complete inspection of the property and they submit you the property improvement plan. And if you are tying up with an international brand, those property improvement plan range between the investment range between 5 to 20 crore rupees. So when you are negotiating in an agreement, property improvement plan will be part of it. And sometimes the default of the owner or a termination will also link to the property improvement plan, that you promise a brand that you will improve the property or either you will invest in the property. It will not happen. That can lead to the termination. Ashish, you like to highlight on this point?
Yes. So it is very important when you are looking at
Yeah.
property improvement plan, because this is something which is pre-decided, and you are putting in the agreement itself that this is going to be
Sure.
the improvement plan, say after 5 years, 6 years, depending on the property. Also, it may be after 3 years, also depending
Yeah.
the brand request also. So when you are
Sure.
negotiating in the agreement, it is very important that you take care of the expenses also, because you are the one who are going to incur the expenses from owners, property owners perspective. If we have to see, it is trying to bring in more funds so that improvement can take place. Now, if again these terms are very important, as we the idea today is to touch upon the important clauses. If
Sure.
there is any delay, again it will attract it may become a curable defect also, or it becomes a problem to the extent that it may lead to termination also. So again, this clause is very important, because if there is no improvement of the property and the plan is not executed, then again it will lead to the termination. These are important terms, because for a brand, they also ensure that the property is maintained to their standards, and for the owner also, because the revenue generation will be depending on improvement also.
Sure. So moving to the next clause, this one is a franchisor responsibility. So franchisor responsibility are generally a responsibility what they agree in a franchise agreement, which is linked with the sales and marketing support, linked with the regular training and audit. Ashish, would you like to highlight on this?
Yes, in fact, it is very important. What generally happens is franchisors' responsibility majorly is also to protect its proprietary rights. Because if those rights are affected, the hotel owners, the property owners will also get
Yeah.
affected. Because suppose there is a litigation which is going on with respect to the brand, and
Yeah.
tomorrow if you are not able to protect it, the interest of the hotel owner will also get affected. So there has to be a balance. Now the responsibility, other responsibilities which are in terms of operations, the next
Yeah.
responsibility comes in is that the training, the standard manual which you are preparing, which is going to get circulated, it is very important that the franchisor provide that support. If that support is not, that training is not taking place, then it will
Yeah.
lead to further complications. And because the brand is all about maintaining certain quality standards, the expectation of a guest is same across all the chains. So they expect that those minimum standards will be maintained. Now, at the same time, if there is a deviation, if the franchisor is not performing his responsibility, it may also lead. It's not just that all the responsibilities are on the shoulder of the franchisee; it is also on the franchisor. And if franchisor is not performing its responsibilities, then obviously the property owner can also ask to cure this defect, and probably it can also lead to termination, because if the franchisor is not performing its responsibilities diligently, then obviously the business is going to affect, and especially owners would like to go for termination in those such cases also.
Okay. So moving to the next point is a franchisee responsibility. Ashish, you like to highlight on this? Franchisee
Yeah,
responsibility, what are the franchisee responsibility now?
sure. So, of course, the maximum responsibilities will be on the shoulder of franchisee because they are the one who are operating the hotel, and the main performance is linked to the franchise franchisee. So it is very important that they comply with the system which has been put up by the brand, and those standards are regularly reviewed also by the. So there is an audit report, compliances are required, and also the compliance with the local laws is one of the key responsibility which is there on the shoulders of the franchisee, because they are the one who are there on the ground level. They are the one who are going to take the maximum number of licenses, approvals, and if those are not there, probably the operations of the hotel will be affected. And also this may affect the brand value also overall, because a brand will be questioned. So suppose tomorrow, if because of some reasons, say if for some reason you have missed out on the fire compliances, it may lead to a material breach. It may be a curable one, but if you fail to cure it within the stipulated time, it will lead to severe repercussions, because brand would not like to continue in that case if it is not cured within the period which is specified. Also, what happens is there are certain audits and reports which you have to give to the brand, because that's how they assess the situation and the business. So it is very important that these compliances are done. These are the responsibilities which are there on the franchisee's shoulder, and these may be considered as curable, non-curable, or material breach of the contract also in case if there is a deviation from that. So this is on franchisee responsibility. Now moving on to the next one, Vijay, I would request you take it over. You throw some light on this because this is a commercial aspect, fees and reimbursable.
Yeah, see, fee and reimbursable, there are three or four kind of different kind of fees in a franchise agreement. The first fee is a franchise fee, which is an upfront fee which you pay to a franchisor for getting a licensing right for using the brand name on your property. Second is a royalty fee, which is linked with the room sales. Third one is a sales and marketing fee or support fee, which is again linked with the room sales. And we have also identified a couple of franchisors. They also charge a fee linked with the F&B revenue as well. So these are the four or five heads of a fee and reimbursable. So in a franchise agreement, it is clearly mentioned that how the fee will be paid to the franchisor, at what time it will be paid, and if there is any default in the paying a fee and or whatever the invoice is generated from a brand, it will lead to some kind of a termination. Ashish, you
Yeah.
like?
So yes. So now, though this is a commercial aspect, which is
Yeah,
well within the purview of both the parties to negotiate really hard on this, and then because ultimately it's money. But at
yeah,
the same time, crucial terms would be whether at what time it has to be paid, within how many days it has to be paid, what if
yeah,
there is a delay in payment. These are the key terms which are included in the agreement, so that the interest of the parties are protected for both. For brand, the payment should come on time. There should be a expenses which are incurred by the brand also, or if some advertisement or some plan has to be there, expenses which have to be incurred, those have to be reimbursed. Now for the franchisee, when this payment has to be paid, if it is clearly stipulated in the agreement, it becomes easier for the franchisee also to proceed further with that schedule. And also, off late we have seen, because of the current situation also, people are insisting that some payment can be done in installments also. This is
okay.
the recent development which we have seen. So it's a good moment, but at the same time, it is something which is negotiable, which parties will have to agree upon.
Okay.
So
So
these are the recent trends also.
let's moving to the next clause, which is annual budget, annual business plan records, reporting, and audit. See, generally in a franchise agreement, franchisor is not responsible for annual business plan or a budget, but the response, like they will advise you, like how the business, what are the things you have to look into an annual business plan, how the budgeting will be done, and they will also give you the parameters from where the brand will provide you the support in. Records, reporting, and audit, they are the standard process. Like they will give you a complete SOP how the reporting will be done. And the auditings are, there are three kind of audit. One is related with the brand. Brand will have a rights to inspect the property anytime, and there are two different kinds of audit. One is a statutory audit, which is hotel owner has to comply with, as well as the internal audit, which hotel owner has to comply with. Ashish, you like to throw
Now,
some light on
yes,
this?
Yeah. So annual business plan, as Vijay has just now mentioned,
Yeah,
it's something which has to be looked after by the franchisee. But at the same time, there are certain procedure which brand would like to have it in the agreement itself. It's a inbuilt system which they would like to have. That this is how the plan will be discussed. There is a procedure which has to be followed. So it's better that these terms are included in the agreement itself. Clearly set out how the plan will be finalized. If there are any inputs, whether it because it should not happen that today if the franchisee comes up with a plan and it is submitted to the franchisor and it is delayed beyond 3 months 6 months, then how you will be able to implement that plan also. So it is very improvement, it is very necessary that these plans are worked out accordingly to the terms which are already agreed
yeah,
upon. So it's better to give a fixed timeline also, that within this time the annual business plan will be finalized and it will be implemented also accordingly. The projections, of course, it's a it is something which will be given by the franchisee, but at the same time how it will be implemented, there will be assistance from the side of franchisor as well. That can be
sure.
included in the agreement. Now the most important aspect is records reporting and audit. What generally happens is these are the places where there can be a leakage also, in terms of revenue for both. Not just at times that there is a possibility that if some staff is under reporting or audits are not done properly, it will lead to some leakages also in the system, which will affect the revenue for both. Now if there is a, for brand, the concern would be that if these audits are not done properly or if there is a leakage, how to fix it also. So these are important terms which also are included in the agreement. And if there is a deviation and if there is a breach, again, as I said earlier, these are the important terms which we are discussing today. If there is a breach, if it is cured, well and good. If not, then it will lead to termination also. So it's better that these are small things, but definitely plays a very important role in overall perspective of the relationship. So it is very important that these audits and reporting is done accurately, diligently, so that especially in terms of the agreement which have been agreed upon. And brand owner also, they request for say quarterly, 6 monthly audit also. So it is a check and balance which can be included in the agreement, and parties can decide whether it should be quarterly or half yearly or probably yearly also, depends. So it is something which they can negotiate on. So moving on to the next one.
So the next important point is the proprietary rights. Actually, I think you can take up this, like this is more related
Sure.
with the legal
Yeah. So proprietary rights. So these are the
proprietary
rights
rights.
which
Yeah,
are there, correct, which are there with the brand. Now when brand comes, you are also using those rights as a licensee, because
yeah,
you are getting this license, and the usage is generally mentioned in the agreement itself, how you are going to use these rights. So for example, your brand, the trademark which the brand has. Now when you are using the stationery and other stuff, say on the internet, when you're putting it on the website also, how you are going to use these proprietary rights. Now these rights plays very important role, because that's how the brand is recognized. And these proprietary rights also goes with the brand. Generally that's how the agreements are built in, because these rights are with the brand. It's a trademark, and then marketing related material, all stationery and everything belongs to the brand. The reason being, because it's their brand, it's their right which is protected also under the law. Now there are certain rights which owner will also have, but again, if they are part of the agreement, and if the relationship is continuing, of course it will help them. But the day there is an end of the agreement or termination happens, then it will affect the proprietary rights, and proprietary rights related to the brand will go with the brand owner, and you can't use it as a franchisee, as a owner of the property. You can't use it, and if you attempt to use those proprietary rights, it will lead to infringement, which will attract both civil and criminal prosecution also. Civil would include penalties and all, damages also, but criminal is something which will also get attracted, because it's a infringement of proprietary rights, including trademarks.
okay. So
So
moving to the next point is indemnification. I think Ashish, you take up this thing
yes,
because we find there are 3-4 clauses which where a lot of debates happen with the lawyer, which is indemnification, termination, and arbitration. So I think now this is something which you can throw a light on that.
very true. In fact, my own experience is that these are the few clauses where agreements will be stuck and parties will be negotiating really hard.
True.
The role which these clauses plays in the agreement and the relationship between the parties is very important, because indemnification is something which is not for present but for future. So suppose today, if some litigation arises, so suppose there is a consumer who goes and files a complaint in consumer forum, what you will do? And at the same time, consumer is also impleading the brand, then what will
True.
happen? So there is some sort of indemnification which is required from the brand side also, because this is something which has happened because of maybe if the breach is committed by the uh, property owner, then obviously brand would also expect that there should be an indemnification to that extent, that the defense, the suit, the pleadings which have to be completed, the defenses which have to be put up, that is something which has to be taken care of by the franchisee. And this cost which is associated with that has to be borne by them. Similarly, if there are some other defaults which happens and for which the property owner is directly responsible, generally we have seen that owner come up with the statement that look at this indemnification clauses, it is purely one sided. But here you also have some scope for negotiation, because on one hand, a brand will be insisting that their interest should be protected, they should be indemnified for any reason whatsoever. Say suppose if there is a tax issue and some prosecution starts, they also look forward for indemnification to that extent, that they should be protected. If any liability comes on their head, it has to be borne by the franchisee. Now, franchisee, on the other hand, can also look at other options. They can insist that whether I should be responsible for direct loss or indirect also. If it is direct, yes. If it's a revenue loss, uh, yes. If it is directly linked to the breach or default of franchisee. So there are various aspects which needs to be looked into, and indemnification is aimed for providing protection to both the parties also. Uh, at times, owners, the brand owner would insist that the indemnification may be restricted to their concerns only. But as a property owner, you can also insist for certain indemnification. So suppose, as I have given an example, that if some litigation is pending and some issue arises because of the brand, then what will happen to the property owner? They should also be indemnified to that extent.
Sure.
So it is something which parties can negotiate, and a good indemnification clause will help you in difficult times. So this is what I have to say on indemnification. There are various nitty gritties which generally worked out when you are preparing the draft of the agreement. So now moving on to the next, another
Moving on to the
key.
next, which is a very important clause, which is the insurance. Insurance, there are two kind of insurance in a hotel business. One insurance is related with the operation liability, and one insurance is related with the property. So generally, most of the time, brand is more looking towards the operational as well as the fidelity insurance. And for a hotel owner, both the operating insurance as well as the property insurance is important. Ashish, you like to throw some light on insurance clause?
Yeah, so insurance clause is very important from operation perspective for the franchisee,
Sure.
and for brand owner. They look for insurance so that if at all if something comes on their head, so they are also protected to that extent. In fact, at times, the brand owners also insist that their name should also be added. Their subsidiaries' names should also be added when they are getting the policies renewed. So these are the things which can be incorporated in the agreement itself. As a franchisee, you may insist that in fact there are times when, say suppose insurance has not been renewed, then
Yeah.
brand can also renew that insurance and can say that this cost has to be reimbursed, and it becomes cost of part of the reimbursable also. So these
Okay.
are the important things which are there. And again, as I said, it is again a key term, key clause in the agreement. If insurance is not appropriate, will lead to a material breach also. Again, the repercussions would be leading up to termination. So it's better that insurance is there in place. You set out the important terms of the insurance itself, that what all things will be covered, whether it will be only operational or with linked to the revenue also. What will be in case if insurance is not obtained by the franchisee, how brand owner will protect get the insurance also.
Sure. Moving to the
So
next clause, our next clause is area of protection, which is one of the very critical clause in the agreement. Area of protection is like if you're taking a franchisee or a licensee of an international brand, as a hotel owner, you can always ask that within a particular radius, whether it could be a 2 kilometer can go up to a 20 kilometer, or either it could be a complete radius of a municipal, like it is complete a radius of a city limits. Like in if you take a franchisee in a small town like Kanpur, so the franchise owner can open a second hotel in a Kanpur. So this area of protection is one of the important clause which a hotel owner to look into while negotiating a franchise agreement. Ashish, you like to
Yeah.
discuss something on
So
that?
just to add to what you have said, Vijay, it is very important because this is more of a future, prospect of the business,
Business.
especially from a franchisee's perspective and for a brand owner also. Because what if there is some, it should not happen that franchisee invests so much, and on the other hand, a brand comes up with a hotel which is just 5 kilometers away from the existing property.
True.
Then that will also dent into the revenue of first property. So
True.
that is
I mean,
very important. And
even the brand have a similar sales and distribution network, and generally we have seen the business get divided between two properties.
very true. And also it restricts, to a great extent, you will also, because you are the first one who have started. So some benefit
True.
should be there for you also for taking
Yeah.
that initiative to bringing that brand in that area. So
Yeah.
that initiative is protected by way of area of protection also, where parties can suggest that okay, this is the territory, physical territory also. In fact, nowadays, when parties are negotiating, they
Yeah.
try to demark it by way of using Google Map, which is very interesting also. That this is the physical demarcation which we are doing for the area of protection also.
Yeah, and they take
So
a complete radius of like if the door of from a door of property till a complete radius of 5 or 10 kilometers area
true,
hotel, a franchise owner can so a franchisor can open a next property within that radius,
very
and it is
this
spread
helps.
all the directions.
Yes, so it helps them. It protects both the sides' interest, not just franchisee for franchisor also. Because what if franchisor feel like that they want to initiate another project in the surrounding area? So
Sure.
at least if the boundaries are clearly demarcated, there won't be any dispute.
Sure.
So now
Moving
moving on to
to
the next one. Yeah,
next clause. Now, this is Ashish, one of the very critical clause, and we find, I think, like if we can or negotiate all the commercial and non-commercial terms, most of the time, a lot of debate and a lot of creativity has been shown by the owner as well as by the brand on the terms and termination. So, over to you.
see, I'll tell you the reason also why this happens, because this
Yeah,
is the one of the most crucial aspect of the agreement, term
true.
and termination. Why
Yeah,
we have these agreements in place? Because on one hand, we are looking at how the party should, govern the relationship in future, and also in future how you want to part your ways also. So it is very
sure.
important, and for what reasons you can part your ways. So this becomes very interesting when parties are negotiating that on these clauses. If there's a breach, then termination will happen accordingly. Now, first, before going to the termination, term is very important. What will be the term? Term
Yeah,
can be the period, as we have discussed, that the tenure of agreement will be 10 to 15 years. Because recently we have seen that the shift has been towards a lesser number of years against 20 years. So now
sure,
the new norm is 10 to 15 years.
sure.
So again, now there can be a lock-in period also, which parties may agree to. As I said earlier, that it will protect interest of both the parties.
Sure.
But also, what happens is if a termination happens. Now, moving towards termination. So suppose if termination happens during that lock-in period, it will attract certain penalties also. And all these clauses which we have discussed earlier also will have an implication on termination, because there is a penalty which is associated with termination during the lock-in period also. And there are times when brand also insists that if a termination happens, then you
Yeah.
are liable to pay me for the entire remaining period. Need not be just for the lock-in period, but maybe for a longer period also. So they
Okay.
also insist for such clauses. Now termination becomes very important because you have to set out as to which all terms, if there is a deviation or breach of those terms, will lead to termination. What should be the notice period? If the breach can be cured, you should give a curable notice also. Notice and the curable period also should be clearly defined in the termination, that it helps them, identifying the areas where a breach is there, and then it can lead up to termination. Now again, uh, next important aspect is, in fact, I'll tell you, when there is a issue with the revenues.
Yeah.
That is the time when franchisee and franchisor wants to exit,
True.
and that is the time people start examining what is there in the termination clause, and then
True.
they try to figure out what all clauses are there in the agreement which will lead to termination of the contract. So it is very
True.
important that the roles and responsibilities are worded properly, which and also which all are very important, which are crucial, which will lead up to termination, should be set out clearly in the termination clause. So this is the a broad perspective on termination, that these points should be carved out in the termination clause at length, and the notice period, and also force measure also becomes very important in termination also, because there, say suppose termination may happen in a month's time also, it can be up to 6 months also. Say suppose if agreements provides that
Yeah.
the termination can be just for 10 15 it may end up in say 1 month time or 6 months time. Now this period of 6 months, it is part of termination only. So how parties will govern their relationship and what will be the effect of termination is equally
Sure.
important, because people and just close the agreement by finalizing a termination clause. But what about the effects of termination? That should
Sure.
also clearly charted in the agreement, because it is very important, because after termination is where the issues arises. So you have to protect that gray area also. It should not remain a gray area. It should be a building block for you also, so that in future when you want to run a because you are the property owner or the brand owner, you want to run your business further. So there shouldn't be any issue because of your previous agreement. So the effects of termination should also be carved out very clearly in the termination.
Okay. Ashish, just wanted to know like what happened if the property get into a NCLT or DRT or either take over by the bank if they are not able to service the debt or has been declared as a non-performing asset. So what happened to the brand agreements? Like generally brand agreements, they don't talk about the recently new IBC code, which are
Insolvency.
yeah,
Yes.
the Indian banking code and the new norms which has come up for NCLT. So what happened to the brand agreements if the property get
So
into NPA or NCLT?
So I'll tell you, if it is become NPA, still it is continuing. But generally, brands on one hand, if it's a, they also try to build in a clause. So earlier, what used to happen is that
Yeah,
people would say that if any insolvency event happens. Now,
yeah,
what is insolvency event? That is something which is defined or under the law, or you can give your own definition also in the agreement.
sure.
But filing of the admission proceedings under the Insolvency and Bankruptcy Code for admission may
Huh.
also lead to such an insolvency event if it is defined accordingly.
Okay,
What generally happens is, these agreements, brand, because to protect their interest, property may go to someone else, but whether they want to continue or not, they try to put in a clause. Of course, insolvency proceedings were hardly mentioned in the contracts, because earlier people used to refer to insolvency event binding up petitions, because that was the regime earlier. Now,
okay,
insolvency proceedings are also captured in the agreement, and then parties put that if there is any binding up proceedings or say insolvency proceedings are filed, there will be some curable period also which will be there. If it happens, well and good. Within that time, if the petition is disposed of, well and good. Otherwise, it may lead to termination.
okay,
Because what happens is, once sorry, probably I'm taking more time, but what happens is, the minute insolvency proceedings are initiated, then it is out of their control. Whose
okay,
control? Property owners control. So it is,
sure.
and in fact they may not be able to. So if it is covered under MSME, which I don't think so will happen, but if it is covered under MSME, then they can submit a resolution plan also and can get the company back on its feet on their own. Otherwise, the existing management will be thrown out. The promoters will be out of the business
Okay,
under the insolvency. So it is very important that the brand owner may not like to continue with the new management or the new buyer who
okay,
comes under the resolution process, comes and
okay,
buys the property. So it is very important that these clauses are also included in the agreement.
okay. So moving to the next clause, which is again a very critical and important, and a lot of time, a lot of debate has been done on the dispute resolutions and arbitration. So over to you.
So this is where the lawyers come into the picture. In fact, the
Yeah,
second set of lawyers who are into dispute resolution, I am also one of those lawyers.
yeah,
So the minute there is a dispute, so right from initiation of notice. But before we get into that aspect, it is very important that the clause is very well worded in the agreement. The
Sure.
dispute resolution mechanism should be provided. Considering the nature of the business in hospitality sector, it is very much important that there should be some sort of resolution should be provided in the agreement itself by way of a first set of talks, by way of a committee which is there in the, you can suggest for a committee, say two representatives from the brand owner side and two representatives from the property owner side can come and meet and discuss the issues which are there, and resolution can happen within a stipulated time. If that doesn't happen, then you can look for other options which are say arbitration, or you can go to the court also. The better
Okay.
option is arbitration because it is a faster mechanism. Now we have seen that people emphasize on three panel of arbitrators. Now that is something which is very expensive because
Okay.
you have to get three arbitrators on panel. Their availability becomes a challenge, and of late with the recent amendments in the arbitration act, the proceedings have to be concluded in a year's time, which is a very faster means of resolving the dispute also through arbitration. Now if there are three panels, three set of arbitrators which parties have to nominate. First they will so agreement can provide whether who will nominate, how it will be, how they will be appointed, and how the third arbitrator will be appointed. Now
Okay.
that becomes a challenge. Instead of that, let's finalize one common arbitrator, and if that is not possible, you can go to the court and get the arbitrator appointed. Now, which court? That is an again important aspect because governing law and the jurisdiction, which court you can approach. On one hand, franchisee would insist that since they are in that particular locality, so the jurisdiction will be given to that particular local court. Whereas brand would insist that we are operating from this city. This is where our corporate office is. Let's have jurisdiction which is of that particular city. So this is something which parties can negotiate. If this is left open, then courts will have to decide, which takes considerable time also. So it is very important that parties should negotiate on this. They should finalize, and once the jurisdiction is finalized, it becomes easier for the parties to proceed further, even if they are disputing or some dispute has to be resolved. Now, as I said, arbitration. Coming back to the arbitrators, I would insist that individual sole arbitrator is the best option, and the method how they have to be appointed can be worked out in the agreement itself. That is where the negotiations takes place. Brand owner may insist that I should be appointing the arbitrator instead of property owner. Property owner would say that no, I should be appointing because if at all if a dispute arises, it is related to my property. So
Okay.
these are the issues which generally arise, and it is better that parties agree to a sole arbitrator, which is a faster mechanism, and
Okay.
dispute resolution can take place. So and also one important factor is what would be the procedure which will be followed by the arbitrators. That can also be set out in the arbitration clause itself, and also which is very important that the arbitration clause is an independent agreement itself.
Okay.
So there is an agreement in the first place, and then the arbitration clause itself becomes an independent contract. So you can set out the entire arbitration process in that clause, and how it has to be worded is something which depends on the parties. They can negotiate some of the key terms I have already discussed.
Yeah.
So it is very important that some emphasize and some time, even if it takes some time, but this is something which should be closed by the parties. And even if it takes some time, let them take that time also. So this is on dispute
Okay.
resolution act.
Ashish, what happened when the arbitration center is out of country? Like a lot of time we have seen in international contract, the arbitration center is selected as a Singapore.
Yeah. So
Yeah.
then see there are when it is an institutional arbitration, so there can
Yeah.
be a set of rules which you can agree upon. And if it is left for the institution to finalize, then generally there are rules which are provided by such institutions. Say
Okay.
there are various
Uh,
institutional arbitration
like
centers.
ICC and SEC.
Yes, exactly.
Yeah.
So they come up with their own, arbitration rules which will be applicable. How which law will govern their relationship also is something which will be either mentioned in the agreement, and if it is not mentioned there, then it will be mentioned in the rules.
Okay.
So that's how they operate, and it becomes easier also because for you to buy institutional arbitration is better than normal arbitration because some of the rules, some of the procedure uh, for you it may not be so easy or comfortable to negotiate, and also at the time of implementation, it becomes
Okay.
easier that if there is an institutional arbitration, then that institution will look after all these aspects right from beginning of the arbitration till the award is passed, and there are set of rules which are already in place, so it becomes easier for parties to just adopt them rather than negotiating them at length. So that also gives them a very good perspective.
Okay. Thank you.
So
I think we cover all the major points of our franchise agreement. Yeah. So thank you, ladies and gentlemen. Thank you, Ashish, for your time, and thank you,
thank
audience,
you
for
very
your time and attention. And if you have any further question related with the franchising, here are the contact details. You can get in touch with us. We'll be happy to hear from you. Thank you.